The purpose of this recording is academic for university assignment only. I recently met with the firm's client, Mrs. Jamie Hogan. She attended seeking advice and options regarding the structure of her business. These are the instructions she provided at our meeting. She's currently running her own small custom cake decorating business. She runs it by herself and plans to continue running it herself. She currently has no employees but is looking at employing 2 possible junior staff members. She is not seeking to expand her business immediately, but is wanting to know options for the future. It is a successful business and runs at a profit. She advised it is a hobby business as she maintains a full-time job, and further that an informal business structure would suit her best due to working full-time. I also discussed and explained liability with Mrs. Hogan. From the instructions provided, it is clear that advice relating to partnerships and joint ventures is not relevant. The business Mrs. Hogan is running does not meet the definition of a partnership as per Section 5, subsection 1 of the Partnership Act, and joint venture isn't relevant because of the High Court ruling in United Dominions Corporation and Bryan Proprietary Limited, where the court ruled the term joint venture connotes an association of persons for the purpose of a particular undertaking or endeavour with a view to a mutual profit, each contributing money, property or skill. It is clear from Mrs. Hogan's instructions there is no association between her and anybody else. The best recommendations for Mrs. Hogan's business structure are sole trader and proprietary company. This is the research I've completed to advise Mrs. Hogan. Mrs. Hogan is currently running her business as a sole trader. It is the simplest business structure available. A sole trader is an easy and formal process, and there is no legislation regarding its structure or management. There is also no registering or reporting processes required, and no requirements to set up the business's own financial accounts like a company. A sole trader is subject to the usual regulations of contract, torts and consumer protection laws. The only issue I raise with being a sole trader is the unlimited liability aspect. Mrs. Hogan and the business are the same legal entity. Her assets and the business assets are one and the same. After researching the Corporations Act and case law decisions, an option for Mrs. Hogan is to register the business as a proprietary company. Although Mrs. Hogan instructed that she wishes for a simple and formal structure, she did also want options for the future. Under the Corporations Act, it is possible for Mrs. Hogan to register her business as a proprietary company as per Section 112 of the Act. This is a viable option for a small private business, and Mrs. Hogan's business fits the requirements of Sections 113 and Section 45A subsection 2. A company registered this way becomes its own legal entity as per Section 124 of the Act. The company's assets and Mrs. Hogan's assets would be separated and owned by 2 different entities. She would have the security of limited liability and the option of expanding the business if she desired. Section 114 of the Act provides a company needs a minimum of 1 member. Section 102A provides for a minimum of 1 director. This rule was established in Solomon's case, the corporate bail, where the separate entities of the company, the directors and the shareholders. This case in particular essentially allows for a one-man company, which is suitable to Mrs. Hogan's instructions. In the case of Lee & Lee's Air Farming Limited, the courts further supported the corporate bail by ruling that the main shareholder and governing director are separate entities to the company and are able to negotiate contracts between themselves. This is relevant to Mrs. Hogan as she could instruct to register as a company and she would essentially be a one-person company. This rule and the rule of Solomon's case allow Mrs. Hogan to be the single shareholder and director and have the option of expanding her business with the protection of the corporate veil. The corporate veil is important as it provides some protection to Mrs. Hogan's personal assets. Although the protection is not 100%, Section 184 of the Act identifies that inappropriate conduct by a director is a criminal offence, and that directors are liable for some of their actions. The legislature governs the internal management of a company. Usually companies will use the replaceable rules from Section 135 of the Act. However, these do not apply to a single director company. Therefore, Mrs. Hogan is able to establish the company's own constitution as per Sections 198E, 201F and 202C allow. These sections provide for the powers of a single director, minimising the formality of the company process. Further, companies have an obligation to keep and provide annual financial reports, as per Section 286. The legislation requires the director to provide financial reports and director reports by Section 292, subsection 2, but only if directed under Sections 293 and 294. This isn't following with Mrs. Hogan's instructions of keeping the business small and informal. However, I believe it's relevant to allow for possible future expansion. As a proprietary company, under the legislation, Mrs. Hogan would be required to follow a lengthy registration process of the company, available in Sections 117 to 123. There is the option of purchasing a shelf company and transferring it to Mrs. Hogan, which saves the time and process. The Act allows for the transferring of companies under Section 601 A The application must be submitted with a special resolution and signed director's statement to ASIC. Further, the Act provides for the voluntary deregistration of a company. I provide this on the basis of Mrs. Hogan's instructions that she likes the flexibility of the informal structure, as she is able to cease trading if she so desires. Section 601 A allows for an application to be made to ASIC for the voluntary deregistration of a company, and provides that Mrs. Hogan as a director is able to lodge the application so long as the requirements in Section 601 A subsection 2 are met. I believe this is relevant as Mrs. Hogan instructed that she wished to keep the business running as a small private business but wanted options for the future. Thank you.